back to Battle Kitola. This is Mujela Olua, and today we want to talk about tenancy agreements. So, do you have a tenancy agreement with your landlord? You should probably go check it now as we speak. And if you don't, you should consider getting one. Very important. What's the position of law on tenancy agreements? The position of law is that you and your landlord are at liberty to reach an agreement on how you want your relationship to be. That's the landlord-tenant relationship. But in the absence of an agreement, the law will prevail. That means that some of the things that are already provided for in the law will be presumed to govern your relations, such as notice period, for instance. An annual tenant, a tenant that rents and pays annually is entitled to 6 months notice, for instance. So if you have done an agreement with your landlord or with your tenant for 3 months notice or 10 months notice, that is what will prevail. But if you have not done that, then the law will prevail. So essentially, tenancy agreements or a tenancy agreement is what connects and regulates landlord-tenant relations. It's very important. So I've made a list of the most important clauses or features, things that must of necessity be in a tenancy agreement. I'll run through them, then I'll take you through a live tenancy agreement, an actual tenancy agreement that was executed several years ago between a landlord and a tenant. Please share this video with your friends, and if you need to speak to a lawyer, check the link in the description box and book a paid consultation slot. Thank you so much. We can always continue the conversation in the comment section. Let's talk about what should be contained in a tenancy agreement. Here I have parties involved. That is of necessity one of the most important features of any agreement, whether tenancy, land agreement, partnership agreement, whatsoever type of agreement. Parties, the parties clause must always be there. Then I put here the description of the property must be there. So you must have something that tells us that this agreement is governing the property at number so and so, or at so street, so area. So very important. The property description, the term of the tenancy, how long it is for, whether 3 months, 6 months, 9 months, 1 year, 2 years, how long it is for. Very important. That clause must be there. Then the rent amount, that is what differentiates a tenancy from several other relations that has to do with property or land. The rent, very important. That's the consideration for value that the tenant gives to the landlord, in exchange for the landlord's okay, you say I should put a sample for you to see as I explain. Well, I said that I'm going to run through the clauses, then I will read out an actual tenancy agreement that was executed several years ago. So I'm running through the content now, the clauses, so that when I'm looking over that agreement, we can pinpoint together that, okay, this is there, this is not there. So I said rent. Rent is very important because thank you, Lionel Cortez. Hi, Emmanuel. Hi, everyone. So, rent is very important because rent is the consideration for value that the tenant gives to the landlord in exchange for the value, which is the possessory rights on the property, while the landlord retains the ownership rights. And then at the expiration of that rental period, the possessory rights returns to the landlord. So he now has both ownership and possession. But he rents out his possession, his possessory rights for a fee. And that fee is what is called the rent. So the rent amount must be stated. Then security deposit, if it applies, it is not a compulsion, but if you want to take a security deposit, if you want to take caution fees too, it should be included in the tenancy agreement, not just wishful thinking or an afterthought. Then utilities, you have to delineate who will be responsible for payment of utilities in the premises or in the property. In most cases, that's the tenant. So, but it depends on what kind of utilities and what kind of property it is, and the living arrangement. For instance, if the landlord is also living in the areas, I've handled some cases whereby the landlord and the tenants are living in the premises, so they share something like a NEPA bill, power bill, power supply. They share the bill, so the landlord pays a part of it. It's utilities, but the landlord pays a part, the tenant pays a part. And then there are instances where you pay to the landlord and the landlord pays for everyone, and there are instances where each person just minds their business and pays for what they have used. So you need to talk about utilities. Other things could be water bill, security levy, community development levy, all those things. You're living in an estate fees also have to be discussed in the tenancy agreement. Who will pay it, when it will be due, and the collection mode if possible. Then maintenance, very important clause. Maintenance must be discussed, must be delineated in a tenancy agreement. You have to talk about who will maintain what portions of the property will be maintained by the landlord, and the ones that will be maintained by the tenant. In most cases, the landlord gets to do the big maintenance, the major maintenance, while the tenant can do, the minor ones and the ones that are directly affected by the fact of his living in the premises or are living in the premises. And in most cases too, the things that are outside of, if it's a residential place, the landlord may be responsible for the maintenance, like maybe if there's a broken fence, or a worn out or a rusted gate. Those things usually, sometimes, let me not say usually, may have to be maintained by the landlord. While things like maybe uh, a room door's hinge coming off, or the handle breaking, or a lever's missing here and there, are usually maintained, repaired, taken care of by the tenant. So that has to be included. Then the use of the premises, very important. Most tenancy agreements will state what the premises are to be used for. So it will state this is a residential building, this is a commercial building, this building can be used for religious purposes, it can be used for a nightclub, it can be used for this or that. And that is why by law, a landlord can eject. When I'm using A or E in these instances, it covers both men and women. So I don't say a landlord or a landlady, and I don't want to say he or she. So please interpret it as such. Very, very important. So um, if the premises has already said that, oh, this premises cannot, if the tenancy agreement already says this cannot be used for a club or any night activities, this is a residential building. The law provides, or the law gives the landlord the latitude to recall his possessory rights, that is to eject or evict the tenant if the tenant uses the premises contrary to the usages specified in their agreement. And this is not just about documented agreement alone, it also covers uh, in most cases oral agreements too. So if you're renting, even if there's no documentary agreement, if your landlord has told you that this my premises, so it is not to be used as a brothel, it is not to be used as a restaurant or a food vending spot. What I'm giving you is an office space. What I'm giving you is a cyber cafe. What I'm giving you is a residential apartment. You have to comply. If you want to derogate, you have to seek the express permission of your landlord and you must consent to it. Else, he is at liberty to eject you by law. So the use of the premises then, whether pets are allowed or not. Many tenancy agreements in Nigeria do not really contain this, while many others also contain it because, pets are a part of. For instance, in some agreements, they may outlaw you bringing dogs into the premises. If it's a shared apartment, the dog will be barking, your neighbors might be complaining. I've in fact handled a case whereby the landlord brought the tenant saying that the other neighbors were complaining that his dog was disturbing them. So if a neighbor has a visitor, for instance, the visitors can't come because they are afraid of the dog. So it was a deal breaker because the man said that the dog was his means of livelihood. That's how he's feeding his fending for his family. Because when he sells their puppies, he makes a lot of money. So he could not do away with the dog. So we went back and forth, and then we were able to reach a consensus at the end of the day, something that was okay by the landlord and by the tenant. But I'm just saying that pets can also be, there could be a pet clause in a tenancy agreement. Are pets allowed? Are they not allowed? What kind of pets? Also, animals in general. There may be a clause that will just outlaw all of them. For instance, you can't rear chickens when you come into this premises. I've also had a case where the bone of contention was the rearing of chickens, and the landlord was contending that the tenant had converted their kitchen, a spot in their kitchen, for rearing chickens. So it was a big issue, and they had to slug it out in mediation. So very important. If the tenancy agreement has outlawed certain pets or animals, you can't bring them in. If the tenancy agreement outlaws bringing in of parrots, for instance, you can't say because you are attached to a parrot or it has sentimental value for you bring it in. You will be crossing the laws, the bounds of the law. So if your landlord were to try to evict you on that ground, they will be justified. So also subletting, that's also a very important clause. The subletting clause, very important. Most tenancy agreements contain the subletting clause. To sublet means that after renting an apartment, you then rent a portion of it out to a third party, and then the rent comes to you. So as such, you are like a mini landlord or a sub-landlord. So you are the subletter, the person you have brought is the sublettee. Although ordinarily, whatever binds you in your relations with the landlord binds the sublettee, it's important to check the subletting clause to see if your landlord or the agreement has proscribed subletting or not. If it is already proscribed, you cannot sublet. So sometimes people rent out an entire flat and then they sublet to maybe two or three other people who pay them, and then they are able to pay the annual rent. People do this for apartments that are very expensive or in eyebrow areas sometimes, or in very close to commercial centers, where up climbing or upcoming, upward climbing, uh, entry level, early career people, live. They sometimes do this. And it could also occur in various instances. Very important to check the clause and to discuss it with your landlord. Are you going to be allowed to sublet? If not, if your plan is to rent at a big fee and then sublet to make back your money, you better abort mission. So subletting very important. Then the notice period. I've said this at the start. You need to know the notice period. It has to be stated in the agreement. If it's not stated, then the law will prevail. So if the law has said that for a 6 month tenancy, you're entitled to 3 months notice, you can, in your own tenancy agreement, increase the 3 months to 6 months notice. You could even give yourselves 1 year notice. Whatever you agree, the court will respect. Because in a plethora of cases, the court has decided that it will not derogate from the mutual agreement of parties in a contract, so long as what they've agreed to do is lawful and there's consensus added in. Please watch the video we did on our contracts, features of a contract, for you to understand consensus added in. So if that is there, the law will not derogate from it. But in the absence of this notice clause, then the law will prevail. And I've given an instance of the law for a yearly tenant. The law prescribes 6 months notice in Nigeria. So the law will prevail in the absence of a tenancy agreement. Then dispute resolution clause is also a very important clause, to state how any dispute arising from the tenancy agreement might be resolved. I was in a training recently and someone was talking, one of the facilitators was talking about how, some people are so reaching and excessive and careless that in the process of maybe dubbing a contract verbatim, without varying the terms to suit their own particular purposes, you find that they have put an arbitration clause in a rental agreement. And when you look at the rent is probably say 1 million naira or a very ridiculous amount, such that arbitration, it defeats the purpose of arbitration, or is it arbitration that defeats the purpose? Because when you consider what you will spend, you know, in going to arbitration, it's just not worth it, and it's not the best fitting solution. So very important to put the dispute resolution clause. Maybe if parties are at dispute, we will go to so and so mediation house or multi-door courthouse, or we'll go to litigation straight, or we will approach this third party to resolve it for us, or we will sit down and discuss it, or we'll give each other notice, maybe notice to quit or notice to resolve the issue or anything. So there must be many agreements keep this, because usually people just move to the determination, the normal determination, issue quick notice, issue owner's intention to recover possession. We've talked about all of these things on the channel. We even done drafts of them on the channel. Please just look for the playlist on tenancies if you want to see most of the things we talked about as far as tenancy is concerned. So dispute resolution clause, then the governing law. You could put this, that okay, this will be governed by the Lagos State High Court, by the Oyo State High Court. Just put the governing law. Of course, the governing law will most times be determined by the location of the property. So if your property is located in a particular locality, the governing law will be that which is applicable there. And then if you're talking about dispute resolution by litigation, you would have to, as of necessity and requirement by law, go to the nearest court, the nearest appropriate court, for the resolving of the issue. So you could also put, there are some other important clauses that are of a necessity included. It's just natural that when you see, or when you're drafting a tenancy agreement, these things are there. Quiet enjoyment clause, that's where the landlord states that they commit to allowing the tenant to have peaceful and quiet enjoyment of the property during the rental period. That just means that they will not be disturbed. Even if you want to enter the premises, we will give you advance notice and we will only come in when you're there. And as to the extent that you permit us, we will not disturb you. We will ensure that you enjoy what you have paid for. And that is multifaceted. It means that on our own part, we will not disturb you, and then we will ensure that we regulate other disturbances outside of you, maybe your neighbors, the locality, the community. We'll make sure that you have peace and quiet. So that clause, and then the access to the premises for inspection, I've mentioned it. So there's also a clause where the landlord has to state and agree with the tenant that if we want to inspect the property, we would come and inspect maybe once a year or twice a year. Would require you to open the door for us and to allow us inspect in your presence, and you state how often the inspection will be and the parts or portions of the premises that you will or may be inspecting and what you may be looking for. So we're inspecting for maintenance purposes so that we can identify what we need to fix and what not, or we're inspecting for so and so purposes. It will come at this time of the year. We'll give you an advance notice of maybe 2 weeks or a few days, and then we will come and then we will go. So very important. Access to premises, that clause should be there. Then insurance is usually not there. And then assigning of the premises to another person. That clause, there's a clause that is also usually contained in a tenancy agreement, which states that when you're leaving the property, you do not have a right to transfer the possession or the rent to another person. So it's different from subletting. Subletting, you're still there and then you're subletting portions to other people. But transferring or assigning now just means that maybe you rented for 2 years and you want to jackpot, you want to leave Nigeria, you just got an opportunity, and you've only spent a year. Then you look for someone that is looking for the exact apartment that you have, they pay to you, and then they use up the rest of your uh, rental period. Or maybe at the expiration of your own rental period, you then look for a tenant that will replace you in the premises. You cannot do that if there's a clause against it. So you need to discuss that with your landlord if it's something that you foresee or you plan on doing, and you need to take note of it in the tenancy agreement if it is there or not. So then the renewal clause too, it goes without saying that if you're an annual tenant, you would renew every year. So there's a clause that will tell you when to renew. I remember I rented an apartment once in Ibadan, and it said that I had to renew, I think, a week before or a month before the expiration of that rent. There's no compulsion really. Landlords have their preferences, but some of these things cannot be compelled by law. The position of law is that you renew your tenancy on the anniversary. Maybe your tenancy is from a certain period to today. So and then as from tomorrow, your rent has expired today. So before tomorrow, you renew today. On the eve of of tomorrow, which is today, you renew your tenancy, your home and dry. But some landlords will want you to renew a month before, 2 weeks before, 2 months before, as the case may be. As a matter of fact, some of them will start calling their tenants. Sometimes it could be those ones that only show up when it's time to pick up the rent. But that clause is usually included. Look out for it so that when your landlord starts disturbing you 2 months to the end of your tenancy, you will not start changing it for each other over the phone or something, or when they come physically, you will not be assaulting each other. You have to look at it. If the clause states, if there's a clause that states that allows them to do that, you have to comply. So look out for that in the tenancy agreement. And if you're a landlord that wants to collect your rent at a certain period, or wants your rent to be renewed at a certain period, put it in the agreement and let the tenant agree and sign so that they know what they're getting into and no one is caught unawares. Then you could also talk about force majeure and early termination. That is to say that, okay, in case you just wake up one day or something happens and you say that you don't want to finish your tenancy, we will refund you so and so, or we will not refund you until so period, maybe when we get another tenant, or when we are able to put the money together or something. A clause that generally just talks about what might happen if you decide to leave before the expiration of your rent, and that's early termination. And then what happens, who bears the brunt where there's force majeure. We talked about force majeure, act of God. That's maybe there's a windstorm, there's an earthquake, a volcano, something that happens without or outside of the powers of man. Maybe because it's destruction. Maybe there's flooding now, and if it floods away, if takes away the gates of the house, who will be responsible? So force majeure clause, that should also be there. Events beyond the control, and to repair or make corrections when such things happen. Who will do that? That should also be included in your tenancy agreement. Now let's see the live tenancy agreement that I have here. I'm looking down because I made some notes, and then I'm going to be reading the tenancy agreement. So let's see what it says in relation to what you have just discussed. This tenancy agreement is made on the 12th day of January 2002 between, so that's the date. I don't think we talked about the date clause. That's how tenancy agreements open, and most agreements in contract law, most contracts, that's how they open. You say this social agreement, maybe this partnership agreement, this, sorry. So you say this partnership agreement, this tenancy agreement, this land agreement, this so and so agreement. That's how agreements open generally. So this tenancy agreement is made on the 12th day of January 2002. That's the date clause between Madam Esther Ajibike of Ajibike Compound, Lakwe, Lagos. I'm changing the private data, the bio data, So I'm just making it up as I go. So in case, hereinafter referred to as the landlady, which expression shall, where the context so admits, include heirs, representatives, and assigns of the one part. This is a very old agreement. So in modern day, lawyers are enjoined and encouraged not to, use such old or difficult terms to understand. So you can just go straight and use plain English. But this is how it's been used. So this tenancy agreement is made on the 12th day of January 2002 between Madam Ajibike, Madam Esther Ajibike of Ajibike Compound, Lakwe, Lagos State, and after referred to as the landlady, which expression shall, where the context so admits, include her heirs, representatives, and assigns of the one part. That's just saying that this the landlady is the one giving out the house, and whoever is representing her, sent by her, maybe her heirs, those who inherit her, those who represent her, this agreement is also binding on them, and they can also exercise authority, in our state as far as this agreement is concerned. That's what it means. And then the name of the tenant, Bayo Ademola of Ademola's Compound, Shaki, Oyo State. So that's usually you use the address of where you're coming from or where you can be traced to as the tenant. Hereinafter referred to as the tenant, which expression shall, where the context so admits, include his heirs, representatives, and assigns of the other part. So we are assuming that Mr. Bayo has migrated to Lagos, for work, and is renting this apartment in Lakwe, for residential purposes. That's a fictitious assumption, but there it is. Then, whereas, that's the whereas clause. The proper, that's whereas is the recital. Most agreements contain recital. That's when you explain what type of property it is and how it came to be and whatnot. Whereas the property hereinafter referred to as the demise premises is a two-bedroom flat which the tenant has viewed and the tenant is satisfied with the same before making payment. You see how nice that is, how nicely that is couched. Yours can be different, but essentially your whereas should show that should show the type of premises it is. Whether it's a hall, it's a warehouse, it's a shop, it's a rental apartment, it's a residential apartment, a duplex, two-bedroom, three-bedroom. Your whereas should show that. And then you can add which the tenant has viewed and the tenant is satisfied with the same before making payments. So that's two-factor authentication, to secure you that this is not under compulsion or deceit. This person has seen what they want to pay for, and that is why we're signing this agreement. Now, the next clause, that's the consideration clause where you talk about money. In law, it's called consideration clause. The last one was the recital. We talked about the date clause, the parties clause, the recital, then the consideration clause. Recital always starts with whereas recital. Then consideration clause. Now witnesses. Now, sorry about that. Now witnessed as follows. I told you it's an old agreement. Yours might not be like this, but essentially, the consideration clause we talk about the money, what was paid in exchange for what value. So now witnessed as follows, that in consideration of the terms and conditions herein stipulated and the rent herein reserved, the landlady lets onto the tenant the two-bedroom flat and its appurtenances. That its appurtenances is always added in tenancy agreements. When you have mentioned the type of property, you say and its appurtenances. It covers everything that comes with the apartment. So if it's a shop that comes with a parking space for the tenant, that comes with a toilet for the tenant, those are their appurtenances. If it's a residential building that comes with a compound, maybe a play area for the tenant's children, a swimming pool area, that comes with a garage for parking, that comes with a gatehouse, that comes with maybe a roof, gazebo, whatsoever. Those are what is called appurtenances. Those things rather are called appurtenances. So the landlady lets onto the tenant a two-bedroom flat and its appurtenances. See to it at Ajibike Compound by Estate Junction, Lakwe, Lagos State. Hereinafter referred to as the demised premises. To hold onto the use of the tenant for a period of 1 year certain, commencing from the 28th day of January 2002 and terminating on the 28th day of January 2003 at a net rent of 100,000 naira per annum. So we're trying to match the value to what things cost then. I hope I'm on track. So this consideration clause has talked about what the type of premises, how much it's been rented out for, and the rental period, essentially from when to when. It must be, and if it's an annual rentage, it must be 1 full year. So it starts and then ends on the anniversary of that 1 year. So from we said 28 to 28. So from 29, that tenancy has already expired. So it must have been renewed before that 29th for the person to continue to hold that tenancy and to continue to subsist as a tenant under this agreement. But we'll probably get to other clauses in front. So at 100,000 per annum. I said in front like a Nigerian, much later. Then the tenant hereby covenant. Now these are the covenants in the tenancy agreement. I think I touched on it earlier. There's what we call the covenants. The landlord covenants to do some things. The tenant covenants to do some things. I dedicated a video about 4 years ago thereabouts. It was in 2020. It was the COVID year, post-COVID. I dedicated an entire video talking about the covenants, the duties of the landlord and the tenant. It's in the tenancy playlist. Please watch it. So the tenant hereby covenants with the landlady as follows. 1, to pay the rent sum reserved immediately the same falls due. That's self-explanatory, res ipsa loquitur. 2, not to break the wall of the demised premises for air conditioner openings, partitions or fittings, or for any other reason without the consent of the landlady. So these are the things that the tenant is agreeing that he will do on his own part. Some could even include things like not to change the paint color of the premises, or if changed, to restore it to its original state when moving out of the premises. So many things. So you look at these things such that if you're not content, you disagree there and then, so that to avoid adaino or stories that touch the heart. Now, Covenant C, to pay all rates, that's tenant covenant C, to pay all rates, tax, assessments, neighborhood charges, estate levies, and outgoings now or hereafter imposed or charged upon the occupier of the demised premises. So some people rent apartments. Oh, Nigerian NEPA is taking lights. So some people rent, I hope you can still see me. Some people rent apartments in Nigeria and they do not want to pay estate fees. They rent apartments in an estate and nobody tells them about estate fees. So estate people will now be mounting roadblocks when they are going to work and be pursuing people. Pay your estate fees. So, and they will be like, I'm a tenant. It's my landlord that is supposed to pay. But I talk to my landlord. Landlord will say, I'm not living there with them. They should pay. So this one has already included that the estate fees has to be paid by the tenant. So to pay all rates, tax, assessments, neighborhood charges. Let's wrap this up because there's no lights. They've taken lights. Estate levies and outgoings now or hereafter imposed or charged upon the occupier of the demised premises. D, to make good and pay for all damages, including accidental damages caused by the tenant, his servants, or licensees to the demised premises or to any part of the demised premises and its appurtenances. E, to use the demised premises for to use the demised premises for residential purposes only. To use the demised premises for residential purposes only. You see that? That's the usage clause we talked about. Not to alter or in any way interfere with the electric cable, switches, junctions, or points or the pipes, taps, or the apparatus installed by the landlady in connection with the supply or use of electricity, water in the demised premises without the consent of the landlady. The tenant shall not, without the written consent of the landlady, affix, erect, or attach on the demised premises or to or through anything that display any placard, poster, notice, advertisement, name, or sign whatsoever. So the tenant shall not, without the prior written consent of the landlady, assign, sublet, or part with or share the possession of the demised premises or any part thereof to and or with another person. You see that clause, against subletting, against assigning or transferring. To observe all rules and regulations prescribed by the landlady or her agents from time to time for the maintenance and use of the demised premises and facilities therein. To permit the landlady, that's another clause, another covenant now, to permit the landlady and or her agent upon giving 48 hours written notice at any time or times during the term granted during the daytime to enter upon the demised premises and carry out an inspection of the demised premises, provided, however, that in case of an emergency, the landlady and or a agent shall have immediate access to the demised premises for the purposes aforesaid. So that's the one that talks about inspection. Very important. To take adequate steps to secure the tenant's personal properties within the demised premises, not to bring on the premises any obnoxious thing or toxic chemical or explosive substance in the demised premises or use the demised premises for any illegal purpose. Now, this is important. We recall that at a period or at a time in 2023, there was, uh, an explosion in an estate or in an area in Ibadan, and it was caused by mining explosives brought into residential property. So if this clause is already there, this is something that the tenant has covenanted not to do. So if it turns out that the tenant did that and caused that amount of damage, then the landlord may sue the tenant. That is if the tenant has not been, affected by the damage irreparably. You sue the tenant, for damages. We talked about damage and damages, injury and compensation. So if there's an injury, by virtue of this covenant, the tenant will be liable to pay damages because here they have covenanted not to bring such substances onto the premises. Very important. Then another covenant, before when this tenancy expires on the 28th day of January 2003, to yield up the demised premises and all additions thereto, including fittings and landlady's fixtures therein. That's just to say, he said before or when, so you can leave before and you can leave on that exact day when your tenancy expires. So you yield up possession, you return possession, you return what you met in the property. And all additions that you make to the property. That's what this clause says. So if it's something that you don't want, you kick against it when at this stage of renting. So because now they said all the additions, whatever improvement you make on the property, you yield it back to the landlady when you're going. So you need to sort this. This is not a fair clause. It is something you should negotiate your way out of at the rental stage, so that it can be removed from the agreement if it's already there. So also there are things that you will find, and then the landlady or the agent, without having lawful authority to agree to it, will tell you, don't worry, that one will not bind you, don't worry, no. It's just template, Do not agree with your agent. If you're not negotiating directly with your landlord, make sure that anything the agent is assuring you of is documented. It's preferably that way. You may find a good agent, a God-fearing agent that will respect a parole agreement or promise. But it's best if you have things reduced to writing. So the continuation of that clause, to yield up the demised premises and all additions thereto, including fittings and landlady's fixtures therein, in tenantable condition. That's a very important clause or word in all tenancy agreements. Tenantable condition. That means that when you are yielding possession back to the landlady or landlord, you must give it back in such a condition that they can rent it out to another person without or with just minimal maintenance and repairs. So tenantable condition, a condition that another tenant can take it and start to use it as soon as you have moved out. Very important, because some people actually come in and they wreck the landlord's property. They go away and they cause a lot of damage in their wake. Some justify it by saying they've paid a caution fee, so the caution fee should be used. And some just go with or without paying caution fee. So very important, you have to return the property in tenantable condition. I remember when I was using on a property I'd rented, an apartment I'd rented, a few years ago. Even I was impressed. And the agent, when he came for inspection, he was impressed with the property because I had used it in such a nice way. And I'm not just saying this because I'm the one speaking here. It's because it's true. I took care of the house. God bless me for that. Such that I did not even want to kill an ant on the wall. I'd rather go and take a insecticide and spray the ants. Like, I really took care of the house. Things that was spoiled when I came in, I fixed them. So I was pointing to the agent. I said, see this one that's spoiled. I fixed it for you. You say thank you, thank you, thank you. See this one that's spoiled. I fixed it for you. Say thank you, thank you, thank you. When it was now time, pay me my caution fee back. You can see that this house, I used it well. You now started telling stories that touch, but that's not why we're here. Now, provided there's a proviso to that clause of yielding back in tenantable condition, provided that the tenant shall be at liberty to remove all his detachable fixtures and fittings in the demised premises, if such removal shall not occasion any damage to the demised premises. So they've qualified the absolute return in the first half by saying that if you can remove what you added without destroying the premises, you can remove it when you're going. And that's usually what I advise tenants to aim at or aim for. So I remember I was mediating a tenancy dispute one time, and the man had done tiles in the shop, a barber shop. So now the landlord wanted him to go. So he was claiming that the landlord wanted him to go because he had fixed up the shop, put wallpaper, tiles, and everything, and so he had increased the rental value of that property. So the landlord wanted to eject him so that he could bring in another person and increase the rent, and that was unfair to him. Then he was now vindictively saying that if the man insists he will remove his tiles, that would be destructive because there's no way you remove the tiles and the shop will be in tenantable condition, except the landlord now embarks on another major reconstruction. But also, he was fighting for his right to a fair deal anyways, and just giving that as an example. So what this clause has said that if it's something you can remove that will not destroy the property, you can remove it. But if it's something that will destroy the tenantable condition in which you're supposed to return the property, you should leave it. You have to yield it back with that thing. So to pay, I never want one silly tenancy agreement I signed. The agreement said that for every nail driven into the wall, I pay a certain amount. But when I got into the property, there were so many nails that had been nailed into the wall by the last user, and the landlord did not fix it for me. He did not fix it. I ordinarily don't like driving nails into walls of people's houses. But I just recalled now as I was talking that they had that clause, but they didn't fix the nails for me. I'm assuming possibly they had caution fee to do it, they did not. Or maybe they refunded the person's caution fee, but they did not restore that property to a tenantable condition as far as those nails were concerned for me. So that's another covenant of the tenant to pay for electricity consumed in the demised premises. Of course, your landlord will not come and pay for you, so But that has to be clear because sometimes people can expect the the impossible. To hand over the keys of the premises to the landlady or a agent upon the expiration of the tenancy. Very important. So if you have not been given any key, like I lived in an apartment where I wasn't given a key, and then the agent said when I was moving out that I should drop the key. I was like, which key? You didn't give me key when I gave. I bought padlocks, I fixed the door handles and everything. You didn't give me key. So if they gave you key, you have to hand it back. If they did not give you, you just make sure the house is secure. Inform them when you're leaving, and they will make arrangements to take it up or take it over after you have moved out. Another covenant to keep the premises clean always. Another covenant to pay a refundable caution deposit of 10,000 naira. That's 10% of the rent. The rent is 100,000, remember? So 10%, 10,000 naira on or before. They put a date to pay caution fee. That one is not necessary, but you have to include the fact that they're paying the caution fee and how much they're paying, so that when it's time to go and they want a refund, it is clear how much they're going to be refunded. Also, I wanted to say about things like to keep the premises clean. It looks very negligible, but it's a very important clause. I've negated several tenancy disputes, especially regarding face me and slap you, face me, I deck your apartments, whereby they're always fighting about who will sweep the corridor and the frontage and the backage or the backyard. They're always fighting about that day. Sometimes they have to do roster. And they say that this person did not follow the roster. This person did not sweep when it was their own time. This person swept their own side of the corridor. They didn't sweep our own side of the corridor. So to keep the premises clean is very important. Then some people come in and say that I'm a working class person, I can't be joining you people to be cleaning. What do you mean I have to clean the gutters? I don't do that. So if someone comes and is saying that if they've signed an agreement to keep the premises clean, they have to comply. So they have to find. It doesn't mean that they should do it themselves. They can pay to have it done. But the important thing is that the premises must be kept clean. It's good for the tenants and it's good for the landlord. So let's go over to the landlady's covenants. Because as the tenant covenants, the landlord must covenant as well. Make promises on what to do. Please watch that important video that I did on the duties of the landlord and the duties of the tenant by law. I think we used the Lagos State Tenancy Law as a case study. So please look at it. The landlady hereby covenants with the tenant as follows: that the tenant paying the rent reserved and performing and observing the several covenants and conditions on his part herein contained shall peaceably hold and enjoy the demised premises during the said term without any interruption by the landlady or any person rightfully claiming under or in trust for her. That means that the landlady, her agents, her proxies, nobody are heirs, nobody are inheritors, nobody will come and disturb the tenant. That's one of the important covenants of a landlord. So if you get into the premises and then the landlord begins to disturb you or begins to facilitate or permit disturbance from their own end, you have a right against them by virtue of this covenant that they've made. So the second covenant for the landlady here, to keep the exterior of the demised premises and the boundary walls and fences thereof in tenantable condition. This is a clause that just ensures that you take care of their property. No, rather, for the landlord, the landlady, this is a clause that makes sure that they take care of the exterior of the property. So, for instance, they could come maybe twice or three or a few times in a year and cut the surrounding grasses, the grasses on the outside of the compound, make sure that the fence is in good condition, make sure that the walls, the fences is safe, the gate is safe, all those things. I think I mentioned it earlier. So this is one of the covenants on the landlord's part. You would most likely be compelled to take care of what you have rented and what is within it. Then without the property, usually goes to the landlord. Not in all cases, it depends on what you agree or what is reasonable in which case. because also some of the things that people fight about in their tenancy is things like, say, okay, the septic tank is full, we should pay for it to be flushed or to be emptied, or maybe we're using estimated bill, want to get prepaid meter, we should pay for it, we should facilitate it, all those things. So most times the tenant is thinking things that I will not take away when I'm leaving. I should not be responsible for maintaining them. The landlord is also thinking things that I'm not using with you while you are there, you're using it. You should take care of them by yourself. So these are competing interests. Now, let's go to the next clause. Provided always, and it is hereby agreed as follows. That's the rent renewal. Oh, there's usually a rent renewal clause. I think I mentioned it, but I didn't call it rent renewal. Rent renewal is the clause that talks about when you are to renew, when you are to pay another one, on what terms and conditions. Then there's also a rent increment clause that is usually in an agreement. Very important. I have not mentioned this one. That is the clause that says that if the landlord wants to increase your rent, they will give you so and so notice in advance, the notice period. And then usually by law, they are supposed to notify you. Then you will sit down and discuss, or you will negotiate and agree. And usually they cannot just continue to increase it, according to their whims and caprices. They are supposed to make some developments or improvements on the property, and then they're supposed to space it. It shouldn't be, often that they will increase the rent. Very important. By law, there's no specified amount. There's no specified period given by law for them to notify you that they are going to increase the rent. Usually, they're just to give you adequate notice. And in many decided cases, the court has held that 3 months, 6 months, and so on is adequate, for you to know that you're going to get an increment on your next rent, and for you to prepare ahead of time. Very important. So now, provided always and it is hereby agreed as follows, that if the rent or any sum payable herein or any part thereof shall be unpaid for 2 weeks after becoming payable, whether formally demanded or not, or if any covenant on the tenant's part herein contained shall not be performed or observed, it shall be lawful for the landlady or her agent at any time thereafter to re-enter the premises or any part thereof. This tenancy shall therefore be deemed terminated, but without prejudice to the right of action of the landlady in respect of any breach of the covenants herein contained. This is a clause that's saying that if you breach any of the covenants, they can evict you, and they would give you 2 weeks notice if you do not pay or renew the rent when you're supposed to. This is not, this is also, this is this is a portion of the rent renewal clause. Now, the rent renewal clause is labeled number 7 in this agreement, and then it has A, B, C. So we're going through it. So now the first A has said that if your rent falls due and you don't pay within 2 weeks, we may eject you, and they may also bring an action against you for any breach of the covenants that you have made earlier that we read. Then B is saying that when this tenancy determines by a fluctuation of time on the 28th day of January, and the tenant does not take effective steps to renew, that's effective steps to renew his tenancy, the tenant shall be entitled to a notice of owner's intention to recover possession only. This is a very controversial aspect, but if it comes to this, you let the court decide. Ordinarily, once you don't, that's why I kept insisting that you have to renew by law. What the law says is you renew on the anniversary of your rent. So if you don't renew, once you cross over to a new year, you have ceased to become an annual tenant. For instance, you are now a tenant at will. For a tenant at will, you are entitled to just 7 days notice. You just notify, it's as if you just saw house as you were going on the road and you moved in. So they just need to give you 7 days rather. But in this covenant, they've been magnanimous. They have even said they'll give you 2 weeks. But ordinarily, they'll just give you 7 days. And after 7 days, they can go to court and get an eviction order to evict you. So what they give is owner's intention to recover possession, no longer a quick notice, so long as by a fluxion of time, that is by the non-renewal of your rent when you should have until it expired, you have now crossed over from an annual tenant to a tenant at will, from a 6-month tenant to a tenant at will, from a 3-month tenant to a tenant at will. So what you're entitled to is owner's intention to recover possession. That if the tenant is desirous of a further term of years, the tenant shall give written notice of such desire to renew for a further term to the landlady or agent, not later than 2 months before the expiration of the term herein granted. The rent for any subsequent term shall be due and payable on or before the last day of the initial term of this tenancy. All I've been saying that if they are still under rent renewal, that if the landlady is desirous of terminating the tenancy granted herein, the landlady shall give the tenant at least 3 months written notice before the expiration of the term herein granted. That the landlady reserves the right to review the rent upon the expiration of the initial term of the tenancy granted herein. Any other Now, the last clause, any notice under this agreement shall be in writing and shall be, this is very important too, because if this is not there, then you can contest how you've been served. If you were expecting a written notice and they sent you a WhatsApp message or a text and you don't get it, you can contest it. So, but this clause takes care of that. The notice clause, let's call it that. Any notice under this agreement shall be in writing and shall be served on the tenant at the demise premises by delivering same to the tenant or any person found at the demise premises, and in case of a notice to be served on the landlady, it shall be served by physical delivery of same to the landlady or by delivering same to the landlady's agent. So then the witnessing clause, in witness whereof the parties hearing have hereon to executed this agreement. Oh my goodness. Oh my goodness. Maker. And I didn't make arrangements for extra life. I don't want to get up. I want to finish this before I get up. Okay. In witness whereof the parties, if I even turn on the gen now, to just disrupt the sound arrangements. In witness whereof the parties herein have hereunto executed this agreement, the day and year first above written, signed, sealed, and delivered by the within named landlady and tenant. So that is the agreement, and then the tenant signed, put his name and signature and phone number and date. The landlady also did the same. Their witness also did this. You also need a witness for a tenancy agreement. Sometimes they even require you to bring a guarantor, because at times are very funny. I think I was challenging an agent as to why they need all those things. They even require you, some require you to bring if you're working, if you're employed, you have to bring a copy of your ID card. So they said that at some point, some have experienced issues, or maybe the tenant having issues in their house, maybe dying or falling sick or leaving the house and locking it up, and then they had nowhere to trace the tenant to, or sometimes even owing while at it. So they put all the security so that if anything happens, they can contact your witnesses or your guarantors. So that is a typical tenancy agreement. So, and you could also have other things, attached, you know, the agent or the landlord may have a special form that they need you to fill and some further detail that they need you to provide. So that's essentially what a tenancy agreement looks like. We've talked about the important clauses and we've gone through a live agreement just to exemplify those clauses. I hope it's clear. I hope that if you're going to sign a tenancy agreement as a tenant in the future, or make one as a landlord or agent, you will consider these clauses. This is not exhaustive, but these are some of the most important things to be included. Whatever type of tenancy it is, whether it's for a commercial building, a residential building, or whatsoever. That's what I have for you in this video or in this episode. Thank you for joining the live session, those that joined. And thank you to everyone that will watch this much later, which is, why we do this so that many people can watch, and receive, and we can make a one size fits all answer as much as possible for a question that applies or bothers several people. I will see you in my very next live session or video. Don't forget to subscribe to those.